Thanks for coming back. And welcome to another session of the Rainy Hangzhou. Hope you like it. I kind of feel sorry for folks who travel 12, 20 hours all the way to Hangzhou just to see this kind of weather, but I have to point out that Hangzhou is kind of beautiful under the rain as well. So I'm Chris. Nice to see you again. I'm Chris from Cantoop. I'm the director of the global operations of Cantoop, and Cantoop means you can reach the top. And today my topic will be focusing on IP enforcement, specifically for anti-counterfeiting. And to provide you today, I'm just going to share some fun facts and some interesting stories with you, and I will leave some time for the interactions as well. So our firm is an IP service firm, and we've been doing anti-counterfeiting in China for more than 20 years, almost 30 years, and we're the first group of people who do brand protection. So in the beginning of our speech, I'll share with you a brief history of Chinese, the IP rights and IP laws in China. So back in almost 40 years ago, the first IP laws, we're talking about the trademarks laws, were first established in China. And after that, after China joined the WTO, there has been gone through several big amendments of the IP laws of China. And the reason for bringing this up is if you look at the history of the Chinese IP law, it's not that long. And some people yesterday said China is the best place for litigations. I would say China is also the best place for anti-counterfeiting and also to put a highest penalty for people who do infringements. Since it's only been a little over 40 years, I remember when we first stepped into the IP protection industry, the authorities, the police, the administrative authorities, they didn't even know how to do or manage the cases. There once was a case over 20 years ago. There was some small infringements by the storefront. The infringements, the authorities just conduct reactions to the infringement. They seize the products, they put the people, they bring the people back to the police station, and our investigators accompanied all the way. And after they put the infringers into the police station, the authorities actually they didn't know how to make notes of the case. They don't know what to put in their notes for the case. So our investigators had to learn from the big companies who entered into China for, say, Mike Vacancy, Rose, and Clifford. We learned from them for some experience, and we have to tell the authorities, oh, maybe you should put in the amounts, the units that has been sold by the infringers, and also how much they have been sold online and offline, and how long they've been doing this kind of business, and also do they have upstream suppliers, and do they have downstream retailers. So that's the situation back in over 20 years ago. Now right now we are very developed, I would say. Like I said yesterday, our company handle over 300 criminal cases every year in China. And criminal cases, unlike in some other jurisdictions, criminal cases in China are very serious, which means if someone involved in a criminal case, there will be permanent records on his or her backgrounds, and this will also affect his or her offsprings from getting educations or for getting into work for the governments. So we handle over 300 criminal cases every year, almost one case each day, and most of the cases are O2O cases, which means it's from online to offline. So throughout the years, we have developed some technical methods, and we also collaborate with authorities and the big platforms like Alibaba, Pinduoduo, Temu, and also some platforms called Weekend, and to acquire some of the sales data behind each store and account. And we also have methods to trace from online to offline IP address and to actually identify the person who's selling the counterfeiting products behind the stores. So some of you would say this is some dirty work of the IP protection, and I call it the last mile of the IP protection as well. So back in 20, 30 years, China has been the biggest supplier of low-end products, unfortunately. And I remember when I was a kid, 20 years ago, I can easily find, I didn't even know what brand is. I don't even know where to find or buy like authentic products. I can easily find counterfeit products for say, for Nike, Adidas, either sportswear and some luxury bags. I can easily find those products on the street in China. And I don't even know where to buy the authentic ones. I don't know the brand behind it. I don't know what is the name behind the brand. So that's the situation back in 20, 30 years ago. And today, China is still, I think, the biggest supplier of both genuine and counterfeiting products to the world, but the manufacturing is shifting somehow because of the whole world situations and tariffs. So some of our manufacturings are shifting from China to countries like India, Vietnam, and some other Southeast Asian countries. And to witness this shift, I think in the future there will be more and more focus in China to be on the copyrights, patents, and trade secrets. And in this process of the transit of China's role, our company has developed from a company that's based in Shanghai, China, to a global company. We have a presence in China, Southeast Asian countries, Turkey, Egypt, North America, South America, and also South Asia. For most of the jurisdictions, we have our own company, own people, and some countries we do it through collaboration. And what we do is we work very closely with a global head of IP councils for many brands, because we represent the brands like Apple, Nike, Chanel, Dyson, Huawei, Samsung, Xiaomi, Schneider Electric, the name goes on. So we serve many global brands. Actually, most of our clients are global brands. And because China has been the origin of the counterfeiting, and we work so closely with a global head of the IP councils, when they have issues in some other countries, they turn to us for help. And the reason behind this is because when we identify a retailer, for say in Turkey, more often than not, the products are coming from China. So when we contact or read actions against a retailer, we can trace back the imports, exports to the Chinese customs. Then we can locate the warehouses either in Turkey or in China, and we can tackle those warehouses and manufacturers, and we trace back to the source of products, which is the manufacturers in China. And that is one of the reasons why we have so many prisons, and we have to have our own people in those jurisdictions. And apart from some other pure law firms, we believe in rolling up our sleeves and getting into the field and doing the dirty works by ourselves. That's why we have a huge investigation team, and we do it all in-house. We don't outsource. We do the investigation works by ourselves. We have over 60 investigators, and we also do the litigations in-house. We have around 10 to 15 lawyers, and just to support our IP enforcements. And I want to do a brief introduction of the different types of enforcement actions in China. So there are basically three tiers or three levels of enforcement actions in China. The lowest one, the lightest one, I would say, is called market sweep. Market sweep was monitored by the market administrative departments, and it's against the street vendors. And it's for like small businesses. I wouldn't even call it small businesses. Some people just we have had cases where people just have a big truck, and when the night comes, they just unload the goods from the truck and start selling by the street. And if you don't tackle them by the night, they'll just move on to another street. So that's a market sweep. And the second level would be administrative actions, which is also monitored by the administrative department. And this is against the storefronts for small businesses. And this is very common back in 10, 20 years, where we can easily find fake Nike stores, fake Adidas stores, fake stores, the stores selling the fake products, and they even have a storefront. But nowadays, it's not that easy to find those kind of infringements. Then the third one, which is the heaviest one, is criminal actions, which is what we focus on most of the time. And the reason for doing that is because our clients, they have very high standards, have very high requirements for brands like Apple or Nike. They don't care about how much money they have to spend, and they don't care about how much money they can get from the compositions. They just want the highest penalty possible to be put on to the infringers. So that's why we conduct lots of criminal actions every year. And on the right side of the picture was action we had last year in Shanghai, right here in Shanghai, which is a market sweep, which is kind of a rare nowadays. And I don't know how long does it take for your authorities in your jurisdictions to take action to an infringer after you file the complaint. But in Shanghai, because we over the years have developed very good connections with the authorities, after we filed the complaint to the authority, it was a Sunday night. The authorities actually just went down for the redaction straightforward, and they said, we'll wait for the documents later, but we'll take the action first so that they don't escape. So the whole action, we only waited for 1 hour to take place. And when I tell this to some of our partners in countries like Mexico, Turkey, or Egypt, they were saying that's unbelievable because some of their actions takes 2 or 3 months, and that's pretty good already. And for this cross-border enforcement action, because nowadays the world is getting more and more connected, and like I said yesterday, most of the Chinese merchants who sell counterfeits, they disguise themselves so well that most of them only sells overseas. And there was a case, we conducted a redaction last year on April, and that's a Chinese e-platform. It's not on any major e-platforms like Alibaba, but it's an individual platform that is very accessible to the rest of the world, except for China. If I go on the website from a Chinese IP address, it will only show authentic products and also the products with no brands. But if I change my IP address to United States and go on the website again, it's another world. The counterfeit products will somehow magically show up. So it's a website like this, and they have very high sales. I believe they sell 1.5 billion to the rest of the world in just 2023. And this was first identified in the United States because there was a customer in the United States who purchased fake sportswear and returned it to the stores in the United States as if it's a real one. And the stores in the United States, they cannot identify the authenticity of the products and got the customer full refund. And the customer actually recorded the whole process and uploaded the video onto YouTube. And that YouTube video got over 1 million views, and the whole platform is just suddenly got so popular and got into some of the brands monitoring. And some of the brands, because this platform involves over 200 brands, some of the brands that turn to us for help. So the first challenge we encountered is they don't sell to domestic China, like I said. If you approach them like a Chinese buyer or any person who speaks Chinese, they will refuse selling any counterfeit goods to you, and there's no way for you to buy anything. So for any cross-border enforcement actions like this, it requires international collaborations, and you can put in lots of efforts on investigations. So what we have done is we collaborate on the brands who's on the North American side, and we collect information. We ask them to do some online searches and also do some online investigations through technical methods. They actually were able to find those TikToks. I mean, the people who run the TikToks, who run the promotion for this website in the United States, and they even found the contracts between this platform and all those people who do the advertise for them in North America. And what we can do is we have investigators in North America, and we collaborate with the brands to conduct an authorized purchase from North America. And after we got the products, record all the process. We even record the process for shipping the products back to China. So the whole process from the products shipping out from China to the United States and from United States to China were all notarized and recorded. And secondly, we conduct some investigations in China, both online and offline. For online-wise, we found that these platforms were actually collaborating with another platform called Weidian in China. And that platform, we have collaborations. And we found that there's one store that withdrew a huge amount of money from the store to a personal account. And we were able to identify that personal account and actually to identify the personnel. But that personnel is not the major suspects behind the scene because he's just a retailer, like I said. We need to tackle the people who run the platform. And in order to do that, we have to relate the evidence for selling the counterfeiting products to the people who actually run the websites. And we were able to do that because we identified some transactions or funds between the retailers and the people who owns the company. So for the whole investigation process, it took more than 6 months for us, and we identified the transaction records, identified the personnel behind the retail stores and also the websites, and we also conduct investigations to the warehouses in Guangdong. And like I said yesterday, there were more than 6 large, gigantic warehouses in Guangdong, and we conduct detections together in 6 different provinces, 4 different provinces and 6 cities, including Hangzhou. And this whole redaction involved more than 200 authorities, 200 police, and including those police that we have to collaborate in the local jurisdictions in Guangzhou, in Xiamen, in Hangzhou. So the whole redaction took more than a week because to seize those products from the warehouses, it took us even longer, around 2 months, because the final seizure of the products is more than 200,000 units of single brand. So that's how we tackle this brand. And that's just one example of the cross-border cases, and we have so many on OTO cases happening every day. And there was a case found on Pinduoduo, which is a Chinese version of Temu. We were able to trace down the IP address of the seller on Pinduoduo, and when we conducted the redaction, we found it turned out to be a Pinduoduo studio in China, which were run by an infringement group. And after we conducted redaction, we were found on their computers that there were more than 100 Pinduoduo stores run by the same group. So that's the kind of redactions and investigations we do on a daily basis. This is my kind of information. I'll leave some time for our interactions for my session, because I think it's very different for every jurisdictions, for people who want to pursue online records from online to offline. And in some jurisdictions, the courts they don't take online evidence. They don't take account into evidence. And in some jurisdictions, yes. So what we're doing is, through our experience over the years, we found that even within China, domestic China, there are some jurisdictions that are better at handling online cases, and some jurisdictions are good at handling traditional cases, like they have to determine how serious the case is by the seizing amount. So what are some situations in your jurisdictions, and do you have any questions, or do you have clients or brands that you represent that has some issues in China? Let's have some discussion. Any questions?
I have a general question about your company's work. So about investigation and counterfeit fighting, how do you actually do that? Do you do that kind of work manually or by using tools like AI stuff? I mean, it seems like you had a lot of cases every year. So how do you split the work between using tools and using people?
Yeah, thank you for the question. That's a very good point. Because we have so many cases, which means if we have 300 criminal cases every year, that means we have more than 1,000 intelligence or potential targets identified every year. So we do that both manually and also we use software. Actually, our company has developed a software by ourselves that can identify potential counterfeits online in the major platforms. So we both use tools and we use people source to find those targets. If you are asking about the identification of the suspected targets.
Yeah, so we know that for some types of IP, it will be relatively easier to identify whether it's infringing or not, like trademark, sometimes copyright as well. But for certain types of IP, like patent, especially utility patents, how do you tell? Sometimes it's even difficult for a person or even for a judge to decide whether it's infringing or not. How can you rely on algorithm to make the call?
Yes, when we talk about the AI search or manual search, we're more talking about trademarks, which are easier to identify. Yes, of course. And we handle not only trademarks, but also patents and copyrights. But I would say our focus has been trademarks and copyrights. For copyrights, we have been working for some gaming companies and also some software companies, and also for companies who produce the Korean dramas. So we've been working on that as well. So for trademarks and copyrights, it's doable to search it by AI. But for patents, I don't think so. For patents, we've worked on several cases, but it's appointed by the patent owners. So which means they know they were being infringed.
Okay, so besides identifying and I guess monitoring infringement cases, what about filing complaints and responding to complaints? Is that type of work done purely by persons, natural persons, or can be done by tools as well?
It depends on which kind of outcome the client wants, because like I said, most of our clients, they want criminal cases, they want the highest penalty to our personnel. So in that kind of case, we need to do the manual investigations to collect the evidence and submit to the authorities in order for them to make it a criminal case. But if you're just gonna file a complaint to a platform for, say, just to close an account or freeze a store, Pinduoduo platform, it don't require anything. We can do that automatically, but most of the cases, that's not what our clients want.
Do you have any other questions from the audience?
Yeah, any questions regarding counterfeitings in China?
I have a question. Based on your presentation, you have done a wonderful job here. You say about every year 200 more criminal cases being filed. The question I follow up with the gentleman is that how you say you go to the public security 公安局 or go to the administration for industry and commerce 工商局 or one administration you say they mentioned here is a criminal. They must go to the public security. So police station, how you can make it? That's really amazing work you have done. Thank you.
Yes, if I'm getting it right, you're asking about how do we communicate and how do we pursue the authorities to make the case happen for us and for our clients, right?
Yeah.
Yes. In general, over the 20 years we've been working in the industry, we've built very excellent relationship with the authorities. In our IP protection industry, we say there are three major sources. The first one is a client, the second one is suspected targets, the third one is authority. But if you don't get the third one, the first two doesn't count. Even if you have the clients, you got the targets, if there's no authorities willing to help you or to give some expedite your speed up your case, the whole thing won't happen. So we've been working with most of the authorities in China, and we build very good relationships because we handle those investigations. We collect the evidence, and we get their acknowledgements for doing that very well. So yeah, we have the relationships, and we even take the clients to the authorities and to the customs for trainings, for communications every year, and I guess that's partially how we achieve that. And the second one is also you need to provide as the suspected targets you provide to the authority, you need to have specific information, and you need to prove those targets are good for you to act. Because they have limited resources and time and manpower, you can prove there's a target that's worth you to dumping all your manpower to invest in several months with us to do the case. So it's kind of our routine work to prove that our brand, our cases, our targets are worthwhile for you to invest in the time and money.
Thank you.
Yeah, it's not easy though.
Any other questions? We have 2 questions.
Thanks, Chris, for the very impressive presentation. So I do have a follow-up question regarding how to identify targets. So as I mentioned yesterday, that we see a lot of customs in China and international in different countries. They seize shipments, counterfeit shipments from China. So when we do the seizure, we can find out who is the exporter in China. But very often the information, the company name is real, but the address, the contact information are fake. So how would you find out where the exporter is and where the supplier is? Even in China, we see a lot of products by the customs, but it's very hard to find out who are the real exporter and who are the supplier. So do you have any suggestion on how to work? Do you have any experience in finding those exporters and suppliers? Thank you.
Thank you for the question. That's a very good point as well. My suggestion wouldn't be too practical because, like I said, we have some technical methods we can trace down to the companies. But it's true that the initial information you get from the customs, either from the Chinese side or to the importing country side, is fake or unuseful, I would say. We've recently had a case for Hindustan Unilever, which is a subsidiary of the Unilever company. We were able to trace down, based on the export and import sheet, to the actual personnel behind it. Because most of the times the names on the export sheet is what we call people, or just an exporting company, not the real retailers or warehouses or manufacturers. But I cannot say too much in detail. I can tell you in detail in person, but we were able to track down to the person who actually, or even if it's just a phone number, that helps as well. We can trace down to the person who actually report or file the export sheet to the customs. And we can use that as a starting point and see what kind of information we can get from that personnel and to the upstreams. Yeah, so the suggestion would still be to file your brands at the customs, because China has a official recordal system for the customs. Some countries do not have. We do have. So it's always good to file your copyrights or trademarks behind the Chinese customs, and have a Chinese company like us or another law firm as your representative. That way, when the Chinese customs identify any potential infringing products, they will get notified.
Yeah, I have one case before. We tried to register one trademark in China for our client. We found the trademark already registered. The Chinese ID company suggests for us to apply for the same trademark as a copyright. We applied as a copyright and it really registered successfully. How this can protect the owner of the trademark and the owner of the copyright in case of conflict.
What kind of products are you talking about?
It was a product, hair dryer, electronics.
Hair dryer?
Yeah.
Hair dryer. There's a lot of cases. Is it a foreign brand, right?
It's foreign brand.
Yeah, there's recently been many cases for foreign brands and even for Chinese exporters who have their own brands overseas, but they're not registered in China. They have people who register the same trademarks or even file for the same similar patents ahead of them. And I would say, depending on the specific case you're talking about, you can give me some more specific information afterwards, and I can have because I don't do patents or I don't do the design or prosecutions, we can have our prosecution team examine your case.
Thank you.
Thank you, Chris. Let's have a big round of applause for this wonderful special talk.
Thank you so much.
Let's move to the next session, that is session 7, copyright challenges, protecting creativity in the age of digital replication. Please welcome our moderator, Mr. Andren, managing partner and counsel lawyers from Romania, along with the panelists Zoe and partner Magenta, partners from China, Dr. Matt Methman, founder and lawyer, Hub Digital Group and ING Group from Netherlands, Maxim Pro, chairman of the board, IP Chain Association from Russia. Let's give them a big round of applause.
See the IP agent here, they say if you have a trademark, you can apply the central trademark as a copyright.
Our job moderator.
They say like this.
Sounds weird. Sounds weird.
Yeah. Yeah, this is my question in general, because he said, no problem, I will apply copyright. How can protect?
Of course, you can apply, of course.
Yeah.
But how is it going to work in protection? Once it stops working.
Copyright is protecting the product.
You can, but for copyrights, it's for Asian. I would say that's straightforward. For trademarks are straightforward.
Hello again, my name is Adrian Rojo, I'm from Romania. We met yesterday, so I will be short. I am pleased and honored to moderate this panel, and I hope that the information provided will be valorous and it will be, I don't know if we will change something, but maybe we will understand something more. So I will leave all the speakers to present themselves.
Okay, thank you. Yeah, I'm Wendell. I'm a former judge at the Shenzhen Intermediate Court with over a decade of experience in legal practice. I spent 6 years in the criminal tribunal dealing with economic crime cases and another 5 years in the IP tribunal handling intellectual property disputes. Since joining private practice in 2017, I've specialized in IP law, and I'm now an IP litigator and a partner at Founder Partner Law Firm. Thank you.
Hello, my name is Depeng Song. I'm partner from Field Fisher. I'm qualified in China and PRC and New York, United States. My practice is mainly about intellectual property and dispute resolution. Very pleased to be here. Thank you.
Yeah, quick and dirty. Pleased to sit on the panel again, and I think you remember what I'm doing from the last panel.
Hello everyone, I'm Maxim Proch from Russia, from IP Chain Association. Is a decentralized platform which fix many kind of transactions with IP objects. And to explain a little bit more, we'll wait for the next section and my colleague Irina will explain. Thanks.
Okay, thank you very much. We will start with some introduction question. So, I would like to know, in your point of view, what has been the most disruptive shift in copyright law over the last 5 years? So, who would like to start?
I'm pleased to start things off. Well, I think the copyright law regime has been revolutionized very much in the past, I guess, not necessarily 5 years, but for longer history. First, by the computer, the rise of computer, and then internet, and then e-commerce, and now AI, blockchain. But if you want to put the 5-year limit there, I think it would be AIGC, artificial intelligence generated content. For other challengers like the internet, computer, or blockchain, what the effect about copyright is about the way works are transmitted, or the way the works are created. But I think what AIGC brings to the copyright world is more revolutionary. I mean, it revolutionizes or challenges the very core of copyright law regime. It put the copyrightability definition into question. It put the authorship issue into question, which are the fundamental things for copyright law. And I think the rise of AIGC also is not only about law, and sometimes it also touches upon ethics, right? So AI, in the past history, everything is built around human beings. Human being can be the only creators, can be the only authors. But now we have AI, which can be equivalently smart, or sometimes more smarter than human beings, and they can create stuff as well. So how to treat or respect the creativity of another subject, whether the works created by AI, which can be more innovative or which are more enjoyable than human created stuff. If we can give copyrights to human beings, why should we not give copyrights to AI? They create much better stuff than human beings sometimes, simply because they are tool, but they are a tool that represents the intelligence of a human being as a whole. So they are trained by human beings' input. They are developed by human beings. So to some extent, they represent a collective intelligence of human beings. So they're simply an AI face, but they represent the wills or the smartness or the knowledge of human beings. Why should we not deny their rights to copyright? So I think a lot of things should be considered with the rise of AIGC, even in the future AGI era. Maybe that would put things into more questions in future.
Yeah, if I follow up your points, I think there is one big shift that was brought up by the internet, because I personally see the internet as being the brain of humanity. What do I mean with that? The internet knows everything, almost everything. I mean, think of your personal life, huh? You're posting something on WeChat, on Instagram, on LinkedIn, as we did a couple of minutes before with our beautiful pictures here. Everybody in the world can see these pictures. Everybody in the world would be easily able to attend this discussion. So it makes things more open and easier to remember. I mean, I still remember when I was a student. The internet already existed. We had our databases where we could check for court decisions, for literature, whatever. When my parents, for instance, went to university, they had to go to the library, find the right book, and so on and so on. Today, it's all with one click, openable and reachable from all parts of the world. that is great. I think really that is great. That is a great achievement for every single human being. And this opens a conflict if it comes to IP ownership. I think first of all, you have a kind of two parties. You have the creator, and the creator, of course, he has a very, very valid interest of being paid for what he has created, or if we think of arts or whatever, or literature, I mean, the interest is not only being paid, it's simply, I want to be in control what happens to my creation. If I'm a painter, I can paint a beautiful picture and show it to nobody. No? Even though if I take a photography of myself, I'm pretty sure I don't want to share it with you, depending on when I took this. I'll leave the rest to you. However, therefrom a conflict arises between the interest of the creator, the interest of the, let's call it, copyright or IP owner or whatever, and the general public. And general public is, first of all, everybody. It's first of, at the second place, it is society. And this public laws have to deal with. Because the function of law is to make a society work, give and provide us all with clear rules that we can understand and that we can respect. And what is the shift we are seeing and facing within the last 5 years, and we will be facing in the very near future, and also in the further future? We are talking about different legal systems, different jurisdiction. That means, if you take again the term of general public is split into various societies. Into the Chinese society, into the Russian society, into the German or Dutch society, into the Italian society. And every society will have different rules how they deal with this conflict of interest. And they might be different, that's a fair point, because of course, I as a German, I respect your Chinese law when I'm in China. What is the problem if it comes to the internet? I probably will not be in China when I'm checking the internet for a photography or for artwork. I will be sitting in my home, in my house in Amsterdam, and the problem is, what law shall I obey? The Dutch law? Yeah, sure. The Dutch society will expect that from me. But you, as the artist in China, what do you expect from me? Of course, to obey your local home laws. And that is the core question. I mean, there is something existing like international laws. But everybody who has ever thought about international law knows, I mean, the possibility to create international standards is very, very limited. It's limited to questions of war and peace in the end, and very, very basic fundamental principles of humanity. So with international laws, I don't expect to deal with these questions. So the crucial point is, how can we deal with that? And that is a very open question. And in my point of view, there is a quite easy way to deal with it. Because when you're checking, when you're using, for instance, the database, and the database actually is what is behind every artificial intelligence. they are relying on a database, whether it's the whole internet or whether it's a part of the internet. What do we have? If you download ChatGPT, if you use Microsoft Copilot, or if you use Chinese systems, what do we all have to do first? What do? You opt in or accept in another way the terms and conditions. And that is actually the legal basis for the reachability of the platform from the user perspective. If you look onto the other side, onto the platform of course has to make sure that it does not infringe or does not conflict with laws of the artists, of whomever. So they will also need to have a kind of contractual relationship. And I think the big shift is that you are moving further and further away from, let's call it, general rulings to terms and conditions. And I think the challenge for the future is to find a kind of standard that is not worldwide. I try to be as visionary as I can, but I'm a realist too. I mean, my nationality is German. We are as conservative and as realistic as you can imagine. But I think the crucial thing is to find a kind of standard that is broadly accepted by platforms to deal with these questions.
It's kind of difficult to establish some standards when we are talking about cross-border platforms, because one of them are based in China, one of them in the United States, one of them in the European Union. So it would be very hard, I believe. But do you believe that in this moment copyright law can be effective when we are talking in protecting creativity? So
it's a common question.
It's common question. Yes. It's a common question. So anybody can intervene.
Before answering this question, I would like to add something to just what I said. You said disruptive changes, but I think I would be careful about using the word disruptive. I mean, not everybody likes changes, but I think it is changes that move things forward, right? And so whether you like it or not, changes are happening every day. So the thing we should think about is to how to adapt ourselves to changes, right? Including the AIGC. So that's one thing that I want to add, and also about the question the question raised by Mark, the fragmentation issue existing around the world about how to treat AI equally. I mean, I think in an internet world, this makes the things even more prominent, because now things happening everywhere. In different jurisdictions, we may face similar issues. So that will make the question of equal treatment more prominent. So everybody will expect equal treatment. The same issue should be treated similarly, whether regardless of where you are. So I think it makes a lot of points to have some sort of international standards that nobody can do form shopping, and there will be more certainty of anticipating what would happen to them if they do something, no matter where they are. But as you said, there would be a lot of difficulties in harmonizing, like copyright law worldwide. I mean, copyright law is, I think it's a law that has very deep connection with a lot of stuff in a specific jurisdiction. It's the economic development of this country, it's the history of this country, it's public policy, even it's the ideology of this country. I mean, copyright concerns. A lot of stuff are not evenly, there are so many differences in all these kind of respects in different areas of the country, right? So regarding this kind of imbalance from country to country, I think it's hard to do that. But I think one viable approach is to harmonize as much as possible from the basic stuff, on a trial and error approach, to see what we can find a common ground to build our position on and then move forward. From this perspective, I think what the EU does, like the EU AI Act, I think may shed some light on that, because I think the EU AI Act it's not very aggressive, right? It avoids regulating a lot of controversial things like copyrightability, like the authorship, ownership, stuff like that. It's mainly about the safety, the security of AI. It makes sure AI does not hurt human beings, does not be a disaster to human society, right? Let the bullet go for a while and see what happens. And that sheds some light. I will look forward to other perspectives.
If I may directly jump in, I think your question, Adrian, was of the role of copyright. Can it safeguard innovation? And that is a discussion we had on a very, very prominent point some years ago, in a time that I personally, and I think most of you, would like to forget. That was COVID time. When the first vaccines came into the market, I remember a huge discussion in Europe, but also worldwide, on should we probably lift the patents and the copyrights on these vaccines. Why would we do so? And that is a situation where I like to take the term of disruption. What the lawmakers were thinking about to do was very disruptive in a purely manner. They wanted to disrupt copyrights and patent rights. Why? To spread the vaccination. Because the idea behind that was, if you break the copyright, you will enable hundreds of companies to produce this vaccine, to speed it up, to explosively produce vaccines, spread them worldwide, and end this pandemic. This never happened, for good reason, I believe, because give this a second thought. If I was a vaccine producer, and probably, I don't know whether you believe me, but I would be one of the good guys. I would produce vaccine to help the people to solve this crisis. Even if I was that, I will have my investors, and you can't explain your shareholders that you are producing something without any copyright protection. So copyright, in my opinion, of course, it helps future developments. The question is only, in my personal opinion, to which extent. And there is, and that is proven by laws in various societies all over the world, the protection of copy, or let's take it a little bit broader, of IP rights, of course, is slightly weaker than for other property rights. They're usually timely limited to 5 years, to 10 years, to 15 years, and that enables us to not to be disruptive, but to be developing and evolutionary. And so I would answer, Adrian, your question with a clear yes, but, but with limitation.
Okay, I want to provide one more perspective from these two questions. We can combine the two questions together. And actually, when we talk about the change in China, I don't think that the real changes has happened in the legislation. Because we already know that the copyright in China have the amendment in 2020, but I don't think this is a big movement about this part. But in the recent 3 years, I think when we talk about AI, we will must talk about we got really very interesting cases in the courtroom. So that's another perspective. And expect when we talk about really can AI generate image can be considered a work, that is an ordinary one. But also we can got another case such like how should we evaluate deepfake videos, and what responsibility do AI service providers have? And also recently we have another interesting case is that if someone turns an AI generated image into a product, is that copyright infringement? So we really got many interesting cases, and also in the copyright framework, and the judges still give very excellent judgment about this different situation. So for me, I think that there's an old saying in Chinese, everything changes, but the essence stays the same. So I don't think that we really need to have a more maybe like the AI law or another kind of law. Just in the copyright law, we can figure out most of the problems, or if not enough, we can have another law such like the anti-unfair competition law. It is also used a lot to protect the AI because maybe they will have some trade secret issues. And also we still got patent law. Yeah, we can also to use the other law to protect the AI, the generate product, or to figure out the problem associated by the AI. So that's my opinion. So thank you.
Andrew, let's go a little bit back to a creator. The another problem is a problem of digital detox. To be frank, we just need to imagine how the author or another creator should work without these full platforms and different instruments and so on. Would he be successful? Or he or she needs to use anyway, every day, every time, AI, internet and so on? What it should be if he or she should go to some village with no internet and so on, and if this creator should have a good work without all of this digital information. That's a really problem because I think that the creativity is using a little bit less nowadays because there are too much digital instruments.
I believe that creativity evolved because now you have to be creative in other ways. Because if before AI you could be creative, I don't know, painting something by your hand, now you can be creative digitally and to prompt different things that your imagination can. I am not I'm not the person who thinks that creativity, so it's enough to be an artist just to prompt different imaginative things. But
so it's just one point. Just because AI can do it doesn't reduce creativity. Otherwise, the Swiss watch industry will be dead. I mean, you pay 50,000 euro, okay, let's see if it's a seagull, for a watch, where you're paying for some old man, young man, to be sitting doing it by hand.
Which actually machines can make more accurately. You know, if you buy a good Italian suit, it will not be as well done as if you buy one from Marks and Spencer or whatever that's made a millionfold, and the stitching, the one that you have on your lapel, it's there to make it look handmade or to be handmade and to show it as the human input. So just because AI could even do it more perfectly, I don't think, to your point, or I'm suggesting, it doesn't reduce the creativity. It's just that somebody else, it's like you go to Vietnam and you can get a Van Gogh painting made beautifully in one day by a Vietnamese copier, right? And even to use that style, AI can do it. You know, do my picture in the style of Starry Night, and then you will look at all the swirls and so on, right? But it doesn't take away from the original creativity. So I think that, Mark, I didn't want to anticipate your point, but just because somebody can do it even more precisely and repetitively doesn't mean that there isn't room to do it the old-fashioned way. You know, the Japanese still dye jeans one at a time. Hey, tell Mr. Levi's that about him, he will say you're crazy.
You're absolutely right, Elliot. There is one thing that is important to keep in back of our minds. I mean, every single time I use such machines, I'm super impressed what the technology can make. I mean, hey, it's not only the cat video. I'm not going to pick up the point with the coding issues or whatever. But I mean, I can tell you a story. Last year I was visiting our Dallas office, and in Texas, what do you want to eat? Super Mexican food. Huh? So what do? You can Google it. Oh, that's old school. Oh, my father would Google it. I asked ChatGPT, hey, I want to eat this and that Mexican food, rating, blah, blah, blah. I'm here, take me there. And of course I was impressed finding a very good Mexican restaurant with solid food. I can't recommend you this restaurant because I forgot everything since I am able to ask Google or ChatGPT. But the core point is the machine. What does it? It's a machine. It's an algorithm behind it. It's not creativity in the meaning of human creativity. And when we are talking about artificial intelligence, we have to make sure, what do we mean with intelligence? We mean with intelligence what so-called IQ checks. Proof, they tell you have an IQ of, I don't know, 140, 590, whatever. What do they check? It's actually your mathematical skills. And that is exactly what the machine does. It follows an algorithm, means not more, calculating 1 plus 1 plus 1 plus 1 plus 1, and then you will have, of course, a Leonardo da Vinci, you will have a new Dostoevsky, whatever. But the machine combines the original Dostoevsky, the original Tchaikovsky, if I may also take the beautiful Russian literature and culture and music onto the stage. But the machine will not be Dostoevsky. That's what, Elliot, again, your slogan from yesterday, artificial intelligence versus real natural intelligence.
Yeah, I think Maxim raised a very interesting point about the creators' interest. About the creators using traditional tools like brushes or pens, and then using computers, Photoshop software, and now using AIs, right? That makes a lot of difference. And that's what the China court decides in the first AIGC copyright infringement case in China. And I think the court actually draws on the analogy between using AI and using traditional tools like brushes or pens. and that's how the court decided the copyright infringement case in an AI era using traditional theory, right? So it looks like that the court does not take the creativity of the AI into issue and is not concerned about the creativity of AI very much. It thinks the human being, the person using the prompts to direct the AI to do the work should get the whole credit for the work. But United States takes rather different approach. I mean, like the case mentioned by Kirk in the previous session, the Danya or the Down case, I guess, the person using hundreds of prompts or even thousands of prompts, but still does not get the authorship. I like the picture a lot. I think it's a fantastic picture. But in the China case, the user only using several lines of prompts and still get the authorship. So that's a huge difference between courts in the United States and courts in China. I think it's worth a lot of discussion on that. So what are the rationales behind the court decisions? Why a same case is treated so differently in two jurisdictions? What the implications of this different this divergence between two major jurisdictions on AI issues would have on the industry on future? But back to the creators example, I would like to draw on my personal experience as well. I'm a creator myself. I'm a blogger. I write a lot of articles. I write intellectual property law reviews. From a competitive angle for a long time. And in the past, I simply read the court decisions and do some research. But now with the AI, with ChatGPT, before I get everything done, I would do a check with ChatGPT to ask specific questions, to ask general questions, to see if to make sure that what I will write down is not already covered by ChatGPT, in order to make my work more useful to the audience. So that means what I need to do is harder than the pre-AI era, because now what you need to out-compete is not only your peers but also AI, right? It knows a lot. It gets a lot of access to all kinds of information, right? You have to think harder. You have to think deeper. You have to make your thoughts more valuable. So I think the rise of AI totally changes the game and spices things up a lot. And I don't know whether it's whether you like it or not, whether it's good or not, but we have to face the fact that it's the truth, and about how to compensate creators. I think that's a very tough question. There are both there are two different perspectives, and both are very reasonable. You could argue that the AI is making creation easier, and you could also argue AI makes creation harder. So how to properly compensate the creators? I think it's worth a lot of more delicate discussion on that topic.
Maybe I have an answer. I'm not sure. Could you please switch on my presentation? Excuse me?
Until the presentation starts, maybe what you write on your blog.
It's just, I think it's one of the last presentation which made without use of AI.
You made it on your own.
Maybe the presentation will enter in the patrimony of AI, and maybe tomorrow it will be prompted.
Of course.
I can't remember when I last made a presentation without AI, huh? I don't know how it works.
It was a challenge.
I believe.
So this is forward, this is backward, and this is forward.
It's a really paintings of painter. Not mine, of course. What I want to discuss, really, these AI systems, they learns to operate a huge amount of data, and many things are with the copyright. And that's why we need to find out how to make this balance between AI development and author rights. Yeah, and really it was evolution of copyright. It was firstly traditional copyright protection. It was focused on reproduction, distribution, public performance, and so on. Then it became digital area, and new types of uses were included at broadcasting, retransmission, and so on. And now we need to think about a new type of using of copyright. We call it extraction. Extraction. What I want to point that it's a new type of using. To use this object, you need to ask the right holder, I think. The problem is how to ask so much right holders. No one can have the personal license. And maybe the more effective way is to implement the collective management right mechanism with some exceptions. For example, I think that we need to have a specific special for science research, for different kind of education research and so on. But of course we need to have a chance to remuneration, to give an offer the remuneration, and that's why this way seems to me quite practical. As for different kind of jurisdictions, as for global agenda, we have conversations in WIPO. Since 2019, the World Intellectual Property Organization has hosted near 11 rounds of discussion on IP and frontier technologies. Also we have Euro directive about specific using of copyright while machine learning, when using machine learning purposes. Also in Russia Federation we have such kind of initiatives, and Federal Council recommended to find how to regulate this field. As Igor said yesterday, now we have not a special regulation for AI, but I think soon we should need to do something to protect author and to protect right holder, because if we say that now we are using it anytime AI, and to be frank, I think 90 or maybe more % of users are absolutely happy to use not copyright-related objects, because they do not need to pay anything, and they are free, and they have access to them, and that's why we need to ask ourselves what the creators should do. How should they live? for what interested. Maybe we will use only handmade bags or tools or something like this, or I don't know. But it's a huge amount of creative people, and don't remember that to have such a material, good databases, good for machine learning, you need to use Dostoevsky and Tchaikovsky and so on. You need to use great authors, because if you have harm in output, you have nothing useful in the end. That's a problem, and let us think about it. Thank you.
Okay, so I have a question for Wei. It's about fair use in AI training. Do you agree with the argument that using copyrighted material for AI training falls under the fair use, or text or data mining exceptions? What limits, if any, should be enforced?
Okay, thank you. There's been a lot of debate on this problem. While I understand the arguments for the fair use and text and data mining exceptions, I think some limits are necessary to keep a fair balance. First, the purpose matters. No commercial research or internal use might be fine, but large-scale commercial training should be approached more cautiously. Second, we should follow the principle of minimum use. Only what is true needed, like summarize, should be used. Copy entire works should be avoided. And the third, we need to look at the market impact. If the AI outputs compete directly with the original works or hurt the license value, then the permission or compensation should be required. And lastly, I strongly support opt-out or opt-in system. And rights holders should be able to say, through metadata or other tools, do not use my content. Yeah, I mean, they should have the right to say so. And also, I think this system is also realistic, because just like the robust protocol, it's this very mature protocol, so I think it's realistic. Okay, that's my opinion. Thank you.
But you know that ChatGPT and DeepSeek and all the AI instruments are mixing a little bit your intellectual property. So if you have a text, he takes it, he makes it a little bit and prompts it to another person who wants an opinion of that. What do you believe about respecting, or how do you pursue your intellectual property if it's mixed by the AI and prompted to some other prompter?
Okay, that's a good question. Actually, it's more like what the law said and what the enforcement could be, right?
Yes, what kind of enforcement, or how do you know as an author that AI took your opera and prompted to somebody else when the opera it's mixed with other words or changed a little bit?
Okay. Actually, I think maybe we can just think about what the robust protocol do. It's more like if we just put my works on the internet, and if the AI try to read, try to copy, or try to do something, they will have some how to say, we'll see the marks from the internet. And maybe that's the way. But I think for many for many scenarios, it will be very difficult to really find the evidence to prove that AI did something to my work. So that will be the really difficult problem.
I believe that it's quite impossible, because in general AI will take and mix your opera with other operas or with similar commentaries or articles, and they will prompt a new opera or a new thing that you cannot realize that it's yours. So you don't have the possibility in this case to tell ChatGPT or DeepSeek, don't use my opera, because you don't know that they have do it. Yeah. So if you have an opera, I don't know, on Amazon or audiobook, you don't know if ChatGPT read it and use it on other prompts. So I believe that that's very hard to say. And here I can go also to discuss a little bit about platform responsibility when prompting this mixed opera.
Sorry, guys, there are technologies, and it depends, of course, how the AI, if it's trained and learns from it, you can't. It's like saying your student who learns how to play the violin through you, if they play a different song, oh, that's my teaching, you can't do that. But, as you know from when we had this whole issue when images started being used on the internet, some companies, not affiliated with us, but Israeli companies especially, have some very good watermarking. The question is, can you adopt it to even taking the most minute slither, the smallest possible, pixel level, or not pixel, but pixel is just a color, but a combination of pixels. That's the question. Can technology catch up? And there's a famous saying by the British judge, technology follows the law, the law follows technology, but behind and limping.
Okay, so I tried this technology myself, and I have the next result. So I made a mixed text. One part of was handwritten, not by hand, but written by a human, and one part was generated by ChatGPT, but ChatGPT used the style of the human, because I prompted use my style and give me a text of about I don't know what. And after that I put it in a program who the program have to see if there is AI in the text. So the program, and it was a paid program, told me that a part which was human written was AI, and the part with AI didn't recognize it.
But the problem is you don't realize you are AI.
Thank you very much.
It was telling you.
I was the source of AI in that moment.
That's why I think there should be definite limits on fair use or the so-called data and mining exception in respect of the training material of AI. I think this is the case. There is similar provision in different jurisdictions. For example, you have to serve a certain specific purpose in order to invoke the exception, such as a teaching and a scientific purpose, or the cultural heritage. To the vision service as listed, set forth in the EU AI Act, in order to use the exception, and the use has to be transformative sometimes, as the US law provides, and it should also make sure that the use does not hurt the creator very much, does not hurt the market very much, to use the fair use doctrine. So it's not like you can use the training material whatever you like it, in whatever manner. So, and also there is a specific provision in EU AI Act which said that the creator can make a reservation. They can say that you cannot use my copyrighted stuff to train AI, and they can opt out. So I think this gives the rights owner some say in the process.
If I act directly, because Adrian, you were asking for platforms actually, and that is very good fitting to your point, since you were saying the creator must have a reservation right, opt-out right, and so on and so on. That is all true. totally agree with you. And what I want to add and bring into the discussion is the role of the platform. The platform, if it comes to replications, if it comes to AI or whatever, they're distributors. They work like Amazon. That is why they are called platform. So they are serving a market, but they are not producing anything. The AI is not producing anything. It is coming back to the logic behind it, to the algorithm. It is searching databases, putting things together, and putting it out on the other side of the platform. Input, output, and the platform right in the middle. It's a kind of distributor. It distributes, if it comes to IP or AI platforms, it distributes information. This information could probably have some IP rights or whatever behind that. And the great advantage of such platforms is the platform, because it's right in the middle, is legally responsible into both directions. And that is why any legal action has clear and very easy to find addressee, and that is the platform. And let me put a very probably libertarian idea or point on stage. I was starting with a point. We have actually two contractual relationships: one to the customer, platform to customer; one creator to platform. And if you look realistically into the world, there is not so many platforms in the world. There are, if it comes to sales, there is in China Alibaba. In the, may I call it in the West?
Where?
May I call it in the West? we have Amazon, yeah, and that's all. And of course, there are many more. You have small platforms, you have big platforms, but they, first of all, they follow the Amazon or Alibaba business model, and that is why I am saying there is need for state action, lawmaking action. There is also need for regulation, but only to a certain extent, because there will very quickly and very easily market standards, if it comes to contractual relationships between creators, between platforms, they will be easily established. I mean, there are standards for sales platforms like Amazon. If I would set up a new mini Amazon in Germany, do you really think, or does anybody in this room think, I would, on a blank piece of paper, write down new terms and conditions? Of course not. I take the Amazon terms and conditions and, amend them a little, but only a little, because it's kind of market standard. And you have that everywhere. Let me bring in some input from the financial services sector. All these financial products, we have worldwide accepted standards. You will sign almost the same contracts. Either your contract is with UBS, HSBC, Deutsche Bank, or with whomever. So this will establish, and that is why I'm arguing. Of course, the state has the role to set simple and clear rules in place. But please, simple and clear. That's all. Yeah?
Yeah, I think this is perfect time to go back to a very big question about whether the copyright law nowadays is still effective in protecting copyright owners' interests. Well, I think now everything is online, and the platform plays a major role in the whole process, as mentioned by Mark. Yeah, so we want to hold platforms like e-commerce platforms or online content sharing platforms accountable for copyright infringement, but we do not want to kill them, right? Because they are very important. They are the platform making, whereby a lot of smaller companies or individuals making living out of, right? So we want to make them responsible, but we do not want to put too much burden on them, right? So how to make the balance, protecting the platforms on one hand and deterring infringement on platforms and also protecting right owners. I think it's a very delicate balance to make, right? And different jurisdictions have different rules. We mentioned the safe harbor rule a bit in the previous discussions. Like the safe harbor rule in DMCA in the United States, and also the notice and the takedown procedure in China law, and also the online content sharing platform rule in Europe. They also have some similar rules, but with some detailed differences. I think generally, I think nowadays the copyright law is still effective. Because we got the safe harbor rules, which makes balance of different stakeholders, and also we have the technical measures as mentioned previously. The watermarks, the other technical measures that the right owners can use in order to prevent infringers. So generally, I think it's effective, but there's more work to be done.
Maybe in the future it will be made like the architects when they put house online. It has something errored, as in you cannot copy, or if you want to make a house with his project, you won't finish it because something is wrong there. So maybe in the future it will be used more the blockchain system to crypt, I don't know, some operas or some things that
I think technology, is a two-sided thing. It can be used by the infringers and it can also be used by the right owners. Yeah.
Okay, in this panel of digital replication, I am curious about the identity protection, and I want to touch a little bit deep fake technology. So I have been a victim of deep fake technology, because on Facebook in Romania I was on different pages promoting a scheme with, of course, illegal scheme, but they took my voice, so if I would hear that video, I would believe that it's registered with my voice. So what do you think, how we can adapt the legislation, or not we, the legislation must be adapted as in to protect the deep fake, protect us from the deep fake technology?
To be frank, I think that deep fake technology is usually used by criminal cases, because you can find many cases it should use in different legal cases which are allowed and so on. And to regulate it, you don't need to use not any IP legislation and so on. It's just a criminal case. It's specific criminal some different cases. You should put it to the criminal court, and it's enough. as for me.
It's kind of hard to pursue a lot of Facebook accounts that are made in I don't know which country, so practically it's very hard.
I totally agree with you, Maxim, and to pick up your point, I mean, nobody says criminal investigation is easy stuff, huh?
No.
That's why we train our policemen and prosecutors very, very good, and I mean, it's their job. I know where you're coming from, yeah? You're coming from, it's a bot that is registered wherever. Or the server is in North Korea, of course there's no chance to have a successful criminal case, but I mean, that's all day stuff. If you go to Berlin and buy heroin at the main station, the chance that you're persecuted is 0. That's normal. And I mean, if you go beyond trying to kill these deep fakes with other measures than criminal law, be aware you're so close before censorship. And I personally, I don't like censorships. But what I mostly dislike if it comes to censorship, I mean, state censorship is one thing. That is the pre-decision of every single society, if they accept and tolerate that, and to which extent. And I never judge on other societies than my own, and that's the Dutch society and the German one. So I will not say anything more to that. However, what I definitely dislike is to let private companies censor because the state simply forces them. That is not all right, and I highly criticize that. And I'm very, very aware of what the consequences of one or the other EU legislation will be in this point, and that is one point where I am very, very open and share my very, very honest opinion with you. I am very, very critical if it comes to such legislation in my home society, in the European Union, and in particular in the Netherlands and in the Federal Republic of Germany. And that is why I totally agree with you, Maxime. That's a question for criminal courts and probably also a civil law question. Because, I mean, if you are deep-faked, you sue Facebook and they will have to put it down and it's a court decision. I mean, good luck with suing Facebook.
Thank you very much.
Well, that's a practical question again, huh? And law is theoretical, not practical.
So the panel has, the time is up, so maybe if there are questions.
Sorry, I think it is getting a little bit late, so everyone is hungry, but I have one additional question. So I've got 2 points actually. So first of all, I think that the court decisions in China in relation to the authorship or the author of the AIGC is not, we call it not consistent, but I think the prevalent point is that the AIGC work cannot be the AI cannot be the author for the AIGC work because we've got one decision saying that the AI can be the author, but it's highly controversial actually. So that's my first point. And the second point is that because Mark, you mentioned platform, and also Adrian, you mentioned platform. So I wanted to extend the question a little bit further. So for example, I'm setting the scene here. If Mark, you mentioned that you use the application to try to locate Mexico restaurant. Assuming that the platform is using So it's more about the unfair competition issue here. It's not just about copyright because it's a little bit. So I just wanted to say that I extend the question a little bit. For example, if the platform use the AI or algorithm to try to recommend some products for you, for the customers. So in this kind of situation, do you think that the platform should be liable for any potential infringement for the product they recommended? Because we also agree that there's some human nature inside the AI, but we're not sure because this algorithm is just like a black box. So do you think that the platform should be liable for them to use the AI to promote or try to recommend this infringing product to the customers?
Well, let me answer the question in two steps. First, the legal situation in the European Union is pretty clear, since there are various transparency obligations for such platforms. That would cover your point. And the second point is we have a competition law, and that applies for platforms, of course, too. My second point, or my second answer to your question is, you ever have to have the practical points in the back of your mind, and it is very hard to make an algorithm transparent. I mean, you can show the code, but nobody in this room, I assume, would really understand it. Huh? So it's a question of shall there be rights? Yes, of course. It's primarily competition law, and this applies for platform like it applies for every other different company. From a practical standpoint, it is of course harder to sue a platform than other businesses. But sorry, I'm a libertarian's mind. I don't recommend special rules for platforms, and that's also true if it comes to competition law.
Well, I think to your question about whether we should let the platform be responsible for the recommended infringing stuff, I think under the current legal framework, it would be hard, especially in China. You know, under the current Chinese law, it's very hard to do that, and you may not want to initiate a complaint even, because you need to be careful doing that, because if you lodge a wrongful complaint, you may be held responsible for that. You may need to take the responsibility, the liability for making a wrong complaint. That's explicitly written in the law. So you need to be careful about that. Basically, I think in order to let the platform be jointly reliable for infringement, you have to prove that the platform has either actual knowledge or so-called red flag knowledge of the infringement. If it simply recommends an item that the platform does not know whether it's infringing or not, I'm not quite sure if you can prove that the platform either has the actual knowledge or the so-called constructive knowledge of infringement.
Okay, hi. I have a question. So I just wanted to get your insights on the practical application of the opt-out method, whereby the creators can opt out and say, this platform you can't use my data or my copyright. So how has it been applied in Europe? So how has this creator been able to opt out? So how do they do this? So do they have like particular agreements with these platforms, or on the platform where they host their intellectual property? So I would appreciate your insight on this.
I don't believe that somebody option to opt out, because I don't believe that somebody knows exactly that his opera is used to be prompted other times. So I'm not sure. I didn't heard of anybody that used the opt-out option to his opera not to be used by ChatGPT or DeepSeek or I don't know other platforms. So
I don't know any case.
So we just have to know now what's the application.
So yes, it's very hard to say, but no, I don't know. Thank you very much.
Thank you for such a compelling session. Now I request a moderator to honor one of our speakers.
They received already, I believe.
We can have a group photo for this session. Thank you so much. Now let's quickly move to our next session, that is session 8, Emerging Tech and IP, Blockchain, Sustainability and the Innovation Frontier. For this, I would like to invite a moderator, Zengin Wang, partner, Globe Law Firm, China, and our expert panelists are Irena, Vice Chairman, Russian IP Transaction Center from Russia, Lens Hu, partner, JHE & Co, Malaysia, Romania IP Consul, Mori Rosit and Francosi from China, Vincent Liu, partner, Richard V. Chambers from Malaysia. I welcome you on the stage. Over to you, moderator.
Introduce yourself. You have a total judgment. You still have one. Yeah, thank you. Okay, thank you. Good afternoon, ladies and gentlemen. Thank you for being with us with this session. The title for our session is Big One. I don't know whether they don't know how much time we have. Okay, especially this session is in front of lunch. Anyway, I'm very happy and honored to be a moderator of this session. In this session, as you can see, we have 4 distinguished speakers from Russia, from Italy, from Malaysia. We will share their thoughts, their remarks about this big topic. And for the reason you must know, we are going to cut our comments and or question part. We just present our opinions, then we go to lunch. We can exchange ideas during the lunch. Is that acceptable? Good idea? Thank you. Okay, our first speaker, Elena, is the vice chair of Russian IP Transaction Center. You can see their introduction in the handout. That organization is focused on the digital transformation of IP software in Russia. Irina will share the Russian IP Center's experience in using blockchain technologies for IP. So the floor is yours, please.
Thank you. No signal. Okay. I would like to talk today about our infrastructure. It's a reality, it's not the future. Public state blockchain infrastructure
of transactions with rights and intellectual property objects. The abbreviated name of the network ARCIS. TCRF network was established in 2017. The previous name of network was IP chain. The object of this public corporate blockchain infrastructure is management of intellectual property rights during all its life cycle stages. The experiment on transformation of the intellectual property rights to the form of blockchain records was implemented within the national program Digital Economy of the Russian Federation. Requirements of the rights transactions were approved by joint decision of the Ministry of Digital Development, the Ministry of Education and Science, and the Ministry of Culture of Russia. Bodies of authorities responsible for legal regulation of digital resources, industrial intellectual property, copyright and related rights. At first, the experiment was successfully carried out by IP Chain Association and then Russian IP Center. Since the network was put into operation in 2018, the specialized work group of the national program recommended enterprises and state bodies of authority to use this infrastructure to solve tasks on intellectual property management. In the world, there are over 100 of projects on blockchain technologies for intellectual property rights management. However, they are mainly aimed at monetization of specific creative products, music, photos, texts. ARCIS network works differently. It allows to record information about any types of creative products as graphic and photographic images, musical compositions, technical and design solutions, algorithms, software, and provide the possibility to work with them, in fact, with any creative product. The range of types of creative products is actively enlarging, and every type may have therefore its own standard of description specific for relevant creative and business field. Transactions through TCRF are free. Every member of the network is charged independently only with the storing of the data copy and interacting with the other network nodes. Transactions may be locked and coded, part accessible only to organization that placed in the transaction. For other organization, access is available with owner's permission. The network divides data into channels. Some of them are open, while certain are available only to the limited quantity of members. It enables to work with confident and locked information, including financial information, as well as to deal with results protected as a trade secret. However, the ARCIS records may be used as evidence in court if necessary. Such a practice has been already implemented not only in Russia but in other countries also. The network supports 6 types of transactions containing the following information. Transaction C, proving the fact of creative product appearance. In the network's terminology, this product is called object. Transaction A, concerning legal protection regime of a creative product and about the holder of exclusive rights of this product. Considering software graphic interface design as an object, it may be not only protected by copyright, but also as an industrial design, and the network saves therefore a full chain of events related to transformation of legal protection regime. Transaction T, concerning agreements with rights, alienation and transfer of right, may be recorded the fact of transfer of rights from the author employee to the company employer, and the fact of transfer of licenses from companies to the other person and legal entities. Transaction B, concerning use of an object, number of use and listenings that may replace users, reports to right holder, revenue information, market value of the object or creation costs. In general, about all that proves the object's worth and demand. Transaction O, concerning infringement of rights to objects and dispute over the rights. Such information may arise within checking on unauthorized adoptions, but commonly it is published by the court, and the points at the court dispute are not at a controversial case settling. And the last transaction G, concerning expert examinations of an object warranting to rank bars the object's originality, novelty, industrial applicability, or absence of unauthorized adoptions. Such examinations are special for different types of objects. This network counted 30 nodes for now. The Federal Service of Intellectual Property publishes information about the objects legally protected as an invention, utility models, and industrial design or a trademark. Also, it can be software information. This information is available for other members of the network and may be used for concluding an agreements with rights. Another this network advantage is possibility to make so-called portfolio agreements with rights when copyright and patent right objects is transferred. It is typically, for example, when concluding franchise agreement with transfer of right of sublicense over software, trademark, as well as promotional materials. An agreement on copyright and patent right transfer is effectuated simultaneously in the network, whilst the registration of rights transfer for object registered in Rospatent will be effectuated soon within consensus directly in the blockchain network. Every member of our network can therefore set up its own services, platforms, and find solutions to manage the rights, from the object created within official duties to commercial solutions of piracy resistance in the internet with the help of this network, that is common infrastructure, the registry of all registries for all services established and corporate solutions. Today, this network is solid based on various solutions for different industries where the work for intellectual rights is vital and essential. The use of existing service allows to drastically reduce the charges of business to the management of rights. The service and platforms may aim at a specific industry or type of object and may be multifunctional. This network has successfully recommended itself among companies that develop software and deposit their source codes. Services records moment of the transfer of right from the developer to the company. They are responsible for unauthorized adoption check and in charge for prevention of possible third parties' rights violations. It is especially important within the use of the open source. This network is also well used by multifunctional depositories that issue the security to any object and provide it with controlled access. A platform preparing all types of agreements with rights works already in the base of network. Open and simple interface for drawing up and practical solutions, and open system of standard for recording of various types of objects and rights. Let find any solution, even in the fields where management of rights is underdeveloped or must be automatic. The system of management of Russian epicenter let effectively build a modern digital and seamless market of intellectual property. So we also open for the new nodes from the different countries because it's open information, and blockchain technology give for us trustworthy environment, and it's a huge data lake about IP objects. Thank you.
Thank you very much. Our next speaker is Julia. Julia is an IP attorney from a leading Italian law firm. Julia practices now in Shanghai. She's the head of a China practice. Julia is admitted to the Italian bar, holds qualification as a UPC representative, and actively contributes as a member of IIPLA Standing Committee on IP and Sustainability. Julia, please.
Thank you. So,
I'm going to open up a bit our discussion. Thank you, Irina, because your insights on blockchain were very interesting. It's a very interesting example on how, in this case, blockchain is helping intellectual property in protection and also enforcement. So I always like to start from this kind of, let's say, analysis, because I think that IP and emerging technologies, they have a special relationship, because, you know, tech is in a certain way, we already know, reshaping intellectual property systems, but at the same time, we don't have to forget that intellectual property always shape tech, technologies and so on. Why? Because it fosters innovation. So most of the times we have great patent filings, a lot of innovation, because we have a reward for this innovation, which comes from patents, from whatever IP rights you can imagine for that sector. So starting from these assumptions, I would like to recap a bit, both from the European and also the Chinese perspective, what's happening in our jurisdiction. As already know, I work for both the jurisdictions, so I would like to bring, connect the dots or something has been already said, of course, but I would like to point out some key points, starting from AI. I think that the most critical issues are right now patents and copyrights, because you already know that there is a problem on inventorship, there is a problem on patentability, but first of all on what is patentable subject matter when AI is involved. What about European Union and China? We both have, of course, patent laws, but also guidelines in order to help patent applicants and also the examiner in deciding how to manage AI algorithms that are involved in patent application. And this is a very interesting point. I don't know how many guidelines we have worldwide, but not so many. And European Union and Chinese guidelines are very similar. Let's remember that the Chinese IP system is in a certain way derived from the German one, and German IP system is very similar to the others member states of the European Union. So that's why also I'm based in Shanghai right now, and I can work with the Chinese market and European clients, because the rules are very similar. But it's just the starting point, because we can also have same rules, but in the end, if we have different approaches with the technologies, we will have different outcomes. Let's say that China has a monopoly on artificial intelligence inventions. Let's take a look to the patent index also in Europe. China is one of the most important patent applicants worldwide, and also Europe for AI and green technologies. So coming back to patents, we have strong similarity in guidelines, and the strong similarities are present in the main points. So about the authorship, the inventorship, we already know that it's totally human-centric, and about patentable subject matter, let's remember that AI algorithm cannot be patented as such, because we need something more. We need the application of AI in a technical sense. We need that AI contributes to the solution, to the technical solution. So technical means for solving technical problems, and it's very important in patent applications that the patent applicant is careful in drafting the legal document. Why? Because you already know that behind the algorithm there is the so-called black box model. It's not something that you just read and you can understand. So let's remember when we draft patents, I'm not a patent attorney, but as a litigator I see the pathology of patent application also, and it's very important to explain in the patent document how we reach the technical
effect. Otherwise, the patent application in first instance will be rejected, but anyway, if we want good quality patents in this kind of emerging technologies, we need to explain, to provide evidence on how the AI algorithms are combining with technical feature in order to reach a technical solution, which of course shall be new and inventive. So explaining how we are going to take that inventive step over the prior art. Second critical point is the one regarding copyright. Already esteemed colleagues have made a great explanation on which is the critical point. I would like just to add some insights from another point of view, because European Union and China, they have strong similarities also in this framework, but with some different, I would say, deriving from the fact that for European Union, maybe for patents, we have more harmonization because we have EPO, which is the European Patent Office. We have strong regulation because you should remember that in European Union, we are 27 member states, and European Union issued different kind of rules. There are regulations that each member state shall implement directly, and then there are also directives which are not directly implemented, but they have to be transposed in the national law, and this can create some fragmentation because maybe you decide, each member state decided to transpose these rules in maybe with slight differences, and so then we have national case law, and maybe sometimes we obtain some fragmentation in the European member states, so we need to keep a lot of attention in this. Speaking about this, I would like to add something about the point of the human, personally creative act in copyright, because it's interesting as Italian lawyer, I can say that we have some case law from the Supreme Court saying that for AI-generated works, we don't have case law specifically on AI, but we can predict how will be the first case, because human creative act is fundamental as input, because especially in Italy, we believe that the creative act must be very personal. So it's not enough to have an idea and create some input in order to obtain a determined output, but we need that the human person decide for the creation. So human personal creative act is fundamental. And on this point, I would like also to add something that we should remember, that artificial intelligence is not artificial intellect. And I think that in this case is particularly true, because intellect is made also with intelligence, but it's not only there is not only intelligence. There is something more that help the creative process. So I think that we should all remember this when we think about how artificial intelligence is impacting our life, because it's not the artificial intellect. We are so far from this, and thanks. What about blockchain? What about blockchain? Blockchain in this case, so if for artificial intelligence we said that IP system is really impacted by artificial intelligence and in a certain way is reshaping the laws. For blockchain, I prefer to say that it's blockchain that is helping intellectual property protection and enforcement. Unfortunately, speaking in particular for European Union, as usual, we don't have the courage to implement this kind of technology so fast as China did actually. Also, China is still experimenting, but there is much more application and pragmatism in use of blockchain. And European Union, as usually, and also Mark already explained the point, we don't like the risk, or at least we like to assess the risk before using the emerging technology. So also in this case, of course, it's not the same of AI level, where there is much more about AI, but blockchain is still under experimental status. There is a slow implementation, there is some draft of regulation, and the European Union would like to focus on creating a infrastructure in European Union based on blockchain services. So they are, for example, experimenting digital diplomas based on blockchain, and they are also working about digital product passport, which is quite interesting because it's going to have the traceability of products. And speaking about this, the traceability of product could be very useful for IP rights because can help in proving the traceability, so the origin and the manufacturing and supply chain phases, and also the authenticity that lead us to think about anti-counterfeiting measures, and could be very helpful for IP system and also for IP lawyers, I would say. Another application, it's the proof of authorship and creation. I mean, I work a lot on creative works and also trade secrets, and in particular trade secrets, it could be very useful to use blockchain in order to have evidence based on blockchain, because at that point the counterparty could not argue. So at this point, honestly speaking, European Union is far from using legal evidence based on blockchain, but thanks China for doing this, because maybe we can take something from China, and China maybe could take something from our regulation approach. And yeah, China is already using legal evidence in IP litigation based on blockchain. Not all the courts, but many of these courts, yes. And it's a good signal, and we can learn something from this. So it's interesting to notice how we have maybe similar rules, but in the very end different approaches, because it's not only about the rules, it's about the policy of each country and how much each country decides to invest. And China it's investing a lot of money in artificial intelligence, in blockchain, and in green techs. And speaking about green techs, also China has a monopoly, because it's not only about IP system, but it's about also the model of scaling globally. And this is very important. And I think that as Italian lawyer and also part of the European Union, I understand the risk assessment and the need of protect individual rights, but sometimes it's also important to have a more global vision, and also to foster more innovation, because all the Chinese models are innovation driven, are very pragmatical. We prefer to have the regulation first and then have everything, so technology and so on. China maybe has shift in this case. I'm not judging. I just think that
is that a technical term? Shift?
Shift.
Shift. I thought China is shit. And we're like, okay, that's a technical term, right? It's short for something like super high, intelligent, T.
So we can see a shift in this, and I repeat myself. I'm not judging our system or Chinese system.
Okay, just checking.
So not judging, actually, I like to work in China for dealing with European clients.
Not anymore.
No, thanks to your comment.
This is recorded. This camera goes all the way.
I know that. Thank you. Now it's recorded.
The Italians say, you can see the headlines. Italy says China is
And I was just saying something very nice about China, so let me finish. Don't provoke me. I was so diplomatic in this speech, and you just, and about
everybody's awake.
Thank you. And so, about diplomacy, I think that we should learn something from this very pragmatic approach. And on this point, I would like to give the words and the floor to my colleagues from Malaysia in order to have a bit of discussion on the different jurisdictions. I already covered too much of the word. Thank you so much.
Thank you, Julia. I think this is a very interesting comparison. One thing, at least one thing I can confirm: China learn how to draft a patent law from European colleagues, especially German legal professionals. That happened 30, almost 40 years ago. That is true. Yes, we do have a lot to learn from each other. Our next two speakers are all from Malaysia. As you may see in this panel, ladies will give their presentation, our gentlemen will make their comments. Okay. The first gentleman, Nance. Nance is an IP partner in Malaysia. He is known for his, I think I admire your skill to solve conflicts between global brands and local registrars. How can you do that? I think it's not easy, at least for me. Okay, Lance, please make your comments.
Okay, I think on top of what Irina and Julia has mentioned, blockchain is actually the way to move forward. But in Malaysia at the moment, blockchain is something still in development, and I think is somehow similar to the EU's position. Malaysia has always been a jurisdiction that we wait for others to implement and then subsequently we just adopt. Even for our legislations, we are all, we pick from India, we pick from UK, we pick a bit from Europe, and then we make our own legislation from there. So in terms of blockchain, I think we are also, we are somehow also taking the wait and adopt approach. But what the Malaysian government has do, they do implement blockchain in the finance sector and also in halal certification. Some of you from, I think most of you from other jurisdictions wouldn't know what halal means. And halal is basically a certification that gives the Muslim people the comfort that the whole chain of process of producing the products are made according to their Muslim standards, which means from the way it is prepared, from the way the ingredients incorporated, sauce, and how it ends up being processed and made into the final products. The whole chain of process has to be halal compliance. And I think blockchain is one of the ways to actually achieve that, to ensure that the whole process is in compliance. But that is, of course, not IP related. And in relation to that part, I think Russia has done a very good job in implementing blockchain in IP assets management and tracking, because I think all practitioners here would face the problem when it comes to litigation for determining your ownership and also somehow in terms of copyright and trade secrets, like Julia has mentioned, we do need to trace back all the way to when it was first created for copyright. And for trade secrets, I think it happens everywhere in the world that employees come and leave from a company and then they somehow take something from the company and then set up their own. I'm sure all litigations here.
That's called theft, by the way.
Yeah, I mean IP theft, but to prove that is very difficult without this tracing of the original, the source of the original document or information. And I think it would be very interesting for the courts or even the parliaments to actually do something about implementation of blockchain. I think reform of laws is always takes a very long time, but judges are the ones that are, I mean, at least in Commonwealth countries, judges are the ones that are being creative in coming into solutions. And I think recognizing blockchain as part of the legal process, like Julia has mentioned, would be very helpful for the whole implementation of blockchain technology in the legal environment. I think that's all the comments from me, and I'll pass to my learned counsel, Vincent.
Thank you. Thank you, Nance. Vincent is an IP lawyer, of course. I think Vincent also had experience working with a Singapore-based multinational technology firm. So, Vincent, the floor is yours.
Thank you, Mr. Moderator. First of all, I would like to say good afternoon, everyone. 大家下午好. Matiya wanakam, and also yes, selamat petang. For Malaysians that we are born and raised in Malaysia, basically to be able to speak in multilingual, that's our strength. And I think on IP awareness side and also catching up with the IP, especially from our fellow colleagues from US, European Union and China, we are still very far lacking behind. I believe my learned friend Lance would agree with me. That's why actually when we first got invited to attend this conference, I think our main objective is here to learn with all our learned friends here instead of to share our insights. Because I would think, personally myself, I sit on the Malaysian Bar Legal Tech AI and Sandbox Committee. We are we have a very close discussions with our Malaysian government, especially on now the hot topic on AI. Those AI related issues, regulations, whether we should regulate it or not. Just now Lance also mentions that actually Malaysia, we always adopt the wait and adopt approach. So now we are actually observing how other jurisdictions tackle or regulate these IP, these AI related issues. But our focus is not so much on IP protection yet, because for now it's more towards on the criminal sides, like actually earlier I've shared with Lance. Currently our Malaysian government focus is to tackle all the criminal element. I believe previous sessions speaker also mentions about deepfakes especially. Now I think it's quite rampant deepfakes, which is also part of the AI technology that is being misused, I would say. Misused in many of the scam transactions, for example, to model after someone's voice or images to be used in the scams or to tout for investments. I think it's a quite concerning issue that's happening in Malaysia, unfortunately. So now the Malaysian governments also in close discussions with the Malaysian Bar. We are trying to come up with a set of law, because it's not governed under the traditional criminal law. If the traditional side, we would say is scam related, is cheating, but now it's with the technology So, but personally, I would agree with what Mr. Zhou律师 yesterday mentioned. Actually, I also believe we shouldn't over-regulate AI when it comes to IP. But for the criminal side, I think to help the prosecutor to successfully prosecute criminals, offenders that misuse AI in achieving their malicious intent, I think that part we should regulate. But when it comes to AI, I also agree with our fellow speakers earlier that shared, actually we have sufficient law. Based on all these years, we have already come up with all these sets of law on patent, copyright, trademarks to govern the creations of AI. So if let's say the laws say something about human interventions or human creations is a crucial part to justify the ownership, I believe that's true, and yeah, we should stick to it. But to a certain extent, we should update our law. As the time moves by, I believe our law should get updated to be in line, in accordance with the change of all this AI environment, to make sure that we have something in place to govern the registrations, to assist our creator of intellectual property to safeguard their assets. But at the same time, we must be very mindful not to kill off the innovations, because I believe that if too much regulations, we tend to kill off innovations. But an updated law would be great in assisting the court to determine what would be registrable, what would be not. So I think this part is still a very grey area in majority of the world. Governments are in talk, I believe. We still have a lot yet to see. I believe in the coming years, AI would not be the same AI that we see today. That's how I observe how fast AI can adopt. From a generative AI, maybe it will transform. That's why we have the ChatGPT called a transformer. And also on the part of blockchain, I believe we have much to learn. I agree, I echo what Len said. We have much to learn from our Russian counterpart, especially on implementing blockchain technology is proving copyright, trade secrets. I believe that's a crucial part. Currently in Malaysia, when we talk about copyright, the notifications or the registrations part is not mandatory like the majority of the world. We adopt voluntary notification approach, but I think the awareness for the artists or the even music composer is very low in Malaysia. That's why we have a lot of leads coming in from the artists, from the music composer, film producer. They are unaware of these IP, these copyright notifications. They always ask for advice, whether it's registrable, how do they prove the ownership, and some of them, they try to Google themselves, which is very common. They say, based on Google, it seems like copyright, we need not to register. Therefore, I can immediately prove our ownership when it comes to infringement. But that's not true when there's a case in court. Normally, the judge would ask, the very basic common questions would be, when you created the copyrighted materials, or who created. Then, if let's say the infringement happens 3 to 4 years down the line after the copyrighted material first created, the owner usually will have a difficulty in trying to prove the ownership because they don't have the documents, or they never recorded it or documented it before. But with the help of this blockchain technology, I believe all these issues will be resolved. It's just a matter of how fast we can adopt this great technology. So I think that's my comment. That's my comment from a Malaysian perspective. Yeah, thank you everyone.
Thank you very much, Vincent. As As we agreed, also for the purpose of the sustainability, lunchtime is, I think 1:20 is our lunchtime. Now it's 1:40 something.
1:40.
So this panel agreed to accept your question during the lunch. Thank you very much. Thank you.
As if they had a choice. Choice is an illusion. We're in China.
Information.
Just carry. It's not for you, I think. The name is wrong.
Thank you so much.
Thank you.
I'm sorry. That's important.
No, that's not. But I already have it yesterday.
Okay. Okay.
真正是好不容易遇到王牌哥了。OK。
我们去哪去了？好。
Upstairs? Okay.
Upstairs?
Yeah, I look at it.
Okay. Good.
我头发很好。
谢谢。